Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need.
Hello there. This is episode 11, where we are continuing with our lawyer panel about complications when different areas of law become interconnected. I'm going to be starting by asking a question to the lawyers, and I think it's self-explanatory, so let's just pick it up there. So, Melissa, in your experience with criminal law and family law and any other adjacent elements, what can you tell us about your observations and issues that you're finding as these areas of law intersect and how abusers may use them to continue controlling behavior?
Right. So often there will be criminal proceedings for what we call, or what is thought of as the criminal violence, sexual assault, physical assault. And at the same time, out of necessity or out of choice, there will be family law proceedings in family court, provincial or supreme. But those processes don't always speak to each other. And so they're occurring at different times in different rooms. In Revelstoke, they would occur in the same room, same day, which has its own challenges. But what occurs is the abuser may be released on conditions under an undertaking or some other similar order. To no go, no contact, that sort of thing. And those will be often done hastily by the police in a moment of need when they're proceeding with the arrest process. So they may not be really well thought out. And that's a natural thing. Obviously, the abuser can apply to vary those undertakings. But what might happen is abuser can't go to the house, abuser can't see mom, abuser can't go where mom is. And so they'll use that in a little way to apply the added pressure of putting all parenting responsibilities on mom, which can be absolutely overwhelming. And so it helps and local crown, or most crowns, are very open to having counsel for, I'll say, mom, contact them to explain the dynamics of the family, because they're only getting information from the lawyer for the abuser. So they're only hearing one side of the whole context, and it can be quite helpful to call Crown and say, I know you're doing such and such, just so you know, here are the practical considerations for this family. And so I've really learned to ask a lot about the practical considerations of the family and to inform Crown or have a conversation with Crown about those realities. So that's something that comes up quite a bit. Also, what can happen is there's just a mindset that when an abuser is subject to an undertaking, well, you don't need a protection order. I hear this a lot. He's on undertakings, that sort of thing. Well, those charges can be dropped and the complainant may not know. Those conditions can be varied and the complainant might not know. And, they might cover different things than what you might need a protection order to cover. So if the abuser is using both processes from the, I'll say the mom's perspective, she might think, I don't have infinite resources, so I'm not going to bring a protection order because there are conditions of release, and I'm going to focus on the parenting stuff that I need. So that's just a practical concern that mom faces. It also sometimes other lawyers will say to me, well, there's release conditions. You don't also need a protection order. And so there's a thought that they're doing the same thing. And I don't know that that's the case. And the length of a protection order is nice, 12 months. Sometimes they need a long time to unravel from what they've been wound up into. And obviously the protection order carries different things. I find that people can't pay for protection orders. Sometimes if legal aid covers it, they can get some representation just for protection order. But where it's a standard family contract and you have 35 hours and it's complex, people think carefully about where they allocate their legal time. And that's so unfortunate because I can sit there and think that the pressing thing is your safety, but they're having to consider their children's safety, their financial long-term stability, their ability to work, and those sorts of things. So I've really had to learn more about asking the right questions, not making my own assumptions, and then digging deeper into financial concerns and practical concerns about parenting. Because back to the energy idea is that it's a long road and they need to have the strength to face these things and prioritize these things, and they need your help to do that. So I'm not afraid to call Crown. I try to ask what other lawyers have been involved so I can contact or create relationships with those people, and try and set them up for a logistical context that makes their life easier so that they can face the legal challenges.
Yeah, Melissa, we see that protection order piece in family policing a lot as well, when a social worker will tell a parent, well, apply for legal aid and then get a protection order. And just bringing it down into the most basic terms, the test that a judge applies for a protection order is imminent risk of harm. Is the harm coming right now? Are you in danger right now? And by the time someone gets they get approved for legal aid, they're finally assigned a lawyer, and they go, I need to get a protection order right now because the social worker said I had to. And it happens less and less, like over the last decade in my area geographically, it happens less, but it still happens. And I have to be very honest, because you mentioned asking specific questions and reaching out to other professionals. I have to be incredibly honest with my client to say, listen, at the moment that you were told this, it may have been a choice for you. However, because we find ourselves now 6 weeks later and there are release conditions in place and he's been following the release conditions based on what you've told me, and it's an invasive process. Actually, if we spoke about the forms earlier, the application for a protection order form is actually, I would say, streamlined a bit compared to what it used to be, which is fantastic. And they've folded the affidavit into it, which means it's one form instead of two. So, I mean, kudos to whoever made that choice. But it is an invasive process, and you're asking a client, especially if you've already been working with them, you have a limited amount of time left in the contract. I often have to say, listen, I don't want you doing this on your own. However, based on my schedule and the amount of time we have left, I can't support you through this process. So I really do recommend you have a support with you, because you're going to be confronted with a lot of information that you may not have thought about earlier. You're going to be asked a lot of these questions. And it's heartbreaking to get to the point where they put together the application and I go over it with them and I say, listen, is there anything else you can tell me? And they say no. And I say, I'm really sorry, you don't meet the test. You don't meet the test. And that can be, it can be really detrimental to the legal relationship, like lawyer-client relationship, on the family, on every level, right? Having to tell a client no, even if it's prefaced with, what you are telling me is very serious, it's very scary, you've made some very hard choices. I believe you've made the right choices by ensuring that you and your children are safe, but this isn't a thing we can do together. The repercussion of that, the echo effect, can chill the trust relationship, not just on the family law side, but then it chills on the child protection side. And then, a client falls, for the family policing, like, that's the area of law where unfortunately I've had the most situations where I can't find a client. They stop communicating with me, months go by, I get served court documents, children have been removed, or there's a supervision order or an extension application, and I have to remove myself from the record. And oftentimes I think to myself, like, if I hadn't had to, right, that hindsight 2020, if I hadn't had to tell a client, even though your situation is serious, I can't help you with this, I often think, would we still be in touch? right? Would we still have a trust relationship? Would they be able to spend their energy communicating with me, knowing that I hadn't been one more person to tell them no? So all those layers.
Yeah, Vicky, I am going to pass it to you next to talk a bit about the overlaps that you see and maybe some of your observations or issues that you've identified when we're talking about family law intersecting with immigration law.
Yeah, I think like one common theme that all of us have addressed is the lack of legal resources, the limited legal aid hours available for either a family law contract or others, but also in immigration, legal aid limits the types of applications that they would fund. So, for example, so let's say post-separation, mom needs to regularize her immigration status. Legal aid will fund what's called a humanitarian and compassionate grounds application, or what immigration lawyers call H&C application for short, so the letters H and C. And that application is for permanent residence. When that application is being submitted, the applicant, mom in this case, is kind of in limbo. The application can take about a year to 3 years to be finalized. And during that time, mom is not allowed to work because she does not have a work permit. There are other immigration applications that mom could apply for, which are called temporary resident permit. And with that, she could apply for a work permit. But unfortunately, legal aid doesn't fund those. So you've got legal aid funding a permanent application, but not the temporary one that allows mom to work. And that hugely impacts the family law aspect, right? Because when we're coming back to what Melissa and Stephanie had said, mom has 35 hours. She's thinking, do I use those 35 hours to get a protection order? Or do I use those 35 hours and focus on parenting? And her current immediate needs are like financial support because she can't work, right? How is she going to make rent? How is she going to feed her children, feed herself, etc.? And we all know as family lawyers how difficult it is to even just get a simple child support order. The lack of financial disclosure from the other side, usually the payer, having to go to court multiple times to enforce financial disclosure also eats away at legal aid hours, right? And so we've got this conflict. You've got the person on the other side who's being a vexatious litigant, not following court orders, etc. And you've got the person, the survivor, who's needing basic needs met, and is quite frankly entitled to child support, if not also spousal support in this scenario, and not having their finances. And so that's just the support issue. But then we also get into parenting issues, where the abuser can bring up to the court and say, look, mom doesn't have status. She could be deported at any time. And so I should get all the parenting time and the parental responsibilities. That could be a consideration that the court takes into account, but I don't think it should be, because the provincial court and the BC Supreme Court does not have jurisdiction to grant immigration status or not. That falls solely on immigration officers. They can take into the factor of whether mom is trying to regularize her status and whether mom has the ability to stay in terms of deciding best interest of the children. But I've seen directions from the court that says dad has to help mom regularize her status. Dad has no obligation here anymore. They're separated, and in the eyes of immigration law, dad can't do anything to help mom. And so again, these two systems not talking to each other and not understanding each other creates a lot of conflict and confusion, and as we've talked about, messiness. when it comes to parenting arrangements, especially when mom's application is not successful. So let's say mom does put in an immigration application, immigration's like, nope, you're not allowed to stay. Then comes up all the questions of, okay, so mom has to leave. Is mom wanting to take the children with her? And if mom wants to take the children with her, then it becomes a relocation application, right? And she has to demonstrate to the court why, why it's in the best interest of the children to relocate. Again, doing all this in 35 hours of legal aid is probably impossible, if not impractical.
I would say too, a real theme in our practice is the abuser is charged. And of course, the complainant often needs to give a statement and be willing to testify for that to proceed to conviction. In the meantime, maybe she hasn't started FLA proceedings or even really wrapped her head around the separation. But what will occur is extreme financial abuse. So emptying the bank account, freezing the line of credit, stopping paying the mortgage, not giving support even though it's ordered or agreed upon or what have you, failing to disclose income. And then I've gone to court so many times where I go to complain about lack of financial disclosure and it gets adjourned and he's given more time. Well, he hasn't done his taxes and he gives him more time. And now all my poor client's time is eaten up with me trying to just get basic financials, or hiding money. Like if you're self-employed, it takes a lot of work for lawyers to go through and explain amortization. And I'm not an accountant. So it's a real frustration on mom. And, her concern is, how do I pay my daycare bill? How do I pay for the gas in my car so I can get my kids to hockey? How do I, and so the last thing that she'll want to pay is a lawyer to figure out, to flesh out his financial statement. So those barriers are real and common and seem to exist often when the abuser is charged, and then it's a reaction towards mom.
And we should clarify for anyone watching and listening that the legal aid generally does not approve time specifically for a division of property. And they also won't approve time for a simple divorce. So we end up with folks who, and what they say is, listen, if you have time at the end of your contract, you can deal with this stuff, but you're not to use it as the primary focus, and we won't approve for the primary focus. So it's, and Melissa spoke earlier about the difference between provincial court, which cannot deal with divorce and division of property, and Supreme Court, which can deal with everything. But for a self-represented litigant and also for a legal aid lawyer who's in provincial court more, it is, in my practice, in my experience, quite a bit faster and more efficient to deal with provincial court if you're not dealing with divorce and division of property. But that property piece certainly comes into effect, and especially well when an abuser has a prolonged period of time that they are able to dispose of assets, hide assets, or simply deny that an asset ever existed, right? There is that aspect of gaslighting there where folks go, I know you had this investment account. And the other person goes, no, I didn't. And then if there are no details, there's no financial institution to make an application to. But of course, even if there was, legal aid doesn't cover those applications. So it's in addition to the question marks, there's also very much that the resources piece. And I'm wondering if now makes sense. Melissa, you talked about once charges have been laid. In the family policing child protection system, I get a lot of situations where complaints are made to police and police are required to inform MCFD or vice versa. There's a protection situation that requires, under their mandates, their policies, the involvement of law enforcement. So I get a lot of situations that are pre-charges, that are during the investigation stage. And if it's not an emergency investigation situation, these things can take months and months and months. Like I'm thinking of one that went from complaint and initial involvement to charges. At least 10 months passed by. Mm-hmm. And during that time, social worker tells the family, listen, here's what we're dealing with. We are going to defer to RCMP. We are going to wait to make any substantive decisions as well, until they've decided whether or not they're going to lay charges. So essentially what we're telling you, family, is that we are going to put some, they call it safety planning. So it's not in the court process, it's pre-court process. We're going to put some safety planning in place that oftentimes involves one parent leaving the home. Or I'm thinking of situations where the parents are no longer together, and a complaint has come in that a police report has come in that mom's current partner, who is not biological parent to the children, mom's current partner has done something inappropriate. And it's this situation where safety planning happens. The new partner is forced to leave the home, but they are huge parenting support to mom. So mom's parenting on her own, right? We talked about that earlier as well. Mom's parenting on her own. Maybe there's a situation where the new partner is able to be with the children, but there needs to be a neutral third party involved as well. So mom can't be supervisor, but it's not, right? It's not completely forbidden in the social worker's eyes. But we've got social worker going, this is kind of how it's going to be until the RCMP have finished their investigation. And then the director, so MCFD or a designated Aboriginal social work agency, then the director will step in and do their own investigation. And so families are going, so what, Stephanie, what can I do? Like, as my child protection lawyer, what are we able to do? And oftentimes the response is, well, there are things, we can be collaborative, we can set meetings, we can have discussions, we can attempt to put in other aspects of safety planning. But social worker and the director always have hanging over my client's head, her family's head, if you don't follow the safety planning, there is a risk of removal. There's a risk that your children will be removed from your home. So my client has to go, okay, what's worse, kids being removed or potentially 10 months, a year of me not having my parenting supports? And then also having an abusive parent hanging over my head in FLA proceedings. Well, you've obviously made an inappropriate choice. Your new partner is under investigation by the police. And the reason they're under investigation by the police is because the abusive parent has made that report to the police. And oftentimes it will involve a very young child, one who's not able to express themselves to police in a way that make the police go, the RCMP go, oh, for sure, either this happened or it didn't. So with a very young child, and oftentimes it involves the abusive parent waiting a few days. The disclosure's made from the young child, or so they state. They wait a few days, they take the child to the doctor says, oh, maybe you should go and talk to the police. And by that point, a week has happened since any alleged incident. And so my client is sitting there going, I wasn't involved in what happened. By all accounts, I wasn't even anywhere near the area. However, I'm being told I have to be protective parent against my partner, who I trust, who I love, who I trust, who has been step parent to my children for a period of time. And again, it's another heartbreaking situation where oftentimes our hands are tied because as legal aid lawyers, as family policing lawyers, because of the limited amount of time that I do have, and because there are no court proceedings yet. If a removal happens or an application from the director, there will be court proceedings. But at that point, like there are opportunities where you can apply for a judicial review. So to have a judge review the decision of MCFD. But at that point, I don't know if anybody here has had experience where they've attempted to judicial review a safety plan. I'm blanking. I don't think I've ever heard of it happening. Maybe it should happen. Maybe that's something we need to work on is whether or not that's even legally possible. But that's a discussion for another day, procedurally. Right. However, that piece of the investigation is still going on. So MCFD hasn't investigated. It's a huge factor, and it gets abused by abusive parents who are going, okay, maybe I don't make an accusation against the other parent, but they've got a trusted adult who's not parent. Maybe that's the person I attack, and then we hang in limbo, and that's right. The waiting is the hardest part, right? Hanging in limbo, not knowing what's going to happen.
We see a lot here too, as a consequence of a safety plan or conditions of release where the abuser has to leave the home. We have very expensive cost of living in Revelstoke, really high rents. And so now maybe the majority payor of the rent or so forth is removed from the home. And he's not necessarily going to find another easy place to live here. So let's say he goes and lives with his family in Vernon. Well, now he's not going to work. And now they can't pay. So the issues snowball and are exacerbated by the financial realities of the family because they're already strained with housing costs. And so sometimes in my practice, I end up helping people with housing issues. And to try and stabilize the family and so that they can go on to the next thing. And that's sort of new because it's gotten quite expensive here, but I'm assuming that's a common experience across the province.
Certainly. I've had parents who've had to, or partners who've had to leave the home on many occasions where it's, oh, I'll take the tent. I'll go into the woods.
Yeah.
I'll go into a park. Like, I know where there are folks camping. And that is then great additional levels of scary, because safety concerns go up, up, up. And then healthcare concerns, right? It's when it's as damp as it is outside, right? It's basic, like, hypothermia becomes all of a sudden another of the layers, right? The hierarchy of needs. Like, are you going to be interacting with legal supports when you literally have to make sure you're not going to die of hypothermia when you're asleep, right? Like, it just keeps inching up, 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 up. And very unfortunately, abusive partners, they're aware of these bits and pieces, right? Everybody, it's on Vancouver Island, everyone's aware of the housing situation. It is very much in crisis. And yeah, if you don't have extended family, and I think that's really that can be the big difference between dire straits and an uncomfortable situation that's inconvenient, is having extended family or having a circle of friends, having those additional folks. But as we often see in abusive relationships, that isolation piece has already been happening for oftentimes years, where mom will come to me and I'll say, listen, is there anyone who can help you out? Is there anybody who can help you do X, Y, and Z? Like, do you have anybody? And the answer is no, I really don't. Anybody I would have contacted, bridges have been burned. When we were still together, my ex made sure that, we had fights. There were, right, all those little pieces. So mom turns around 3 years later and goes, oh my gosh, like, he made it so I only had him, and now I have nobody. And it's so scary. It's so scary.
We see that for women who have precarious immigration status too, right? Because oftentimes they're coming here somewhere else, they don't have a community, and they meet the abuser. Either the abuser erases all their community and isolates them, or keeps them isolated so that the survivor can't make a community and can't make friends, and have no one to go to in times of need.
Well, and on the Family Law Line is a service provided by Legal Aid BC, and you access it by calling the regular Legal Aid BC intake phone number. Thankfully, there is the option to have an interpreter on the line for those calls if folks book in advance. So if callers can get past the barrier of speaking to the intake person, usually in English, if they can have a support, or if they can, piece it together based on context, essentially, we're able to have an interpreter involved. It's a little bit more complicated when you're a legal aid lawyer to include an interpreter on a regular basis. Like, you essentially have to keep applying for authorization from legal aid, like, once you've maxed out that line item on the disbursements. So it's another concern, because I've dealt with people who didn't even know what a social worker was, that have, newcomers to Canada who are going, I didn't even know this was a thing that could happen. Right? Because this is so far out of my wheelhouse. I was not familiar with Canadian culture, so-called Canadian culture, when I came to this country. I don't speak the language, and certainly it's a situation where, of course, if I don't speak the language that's being interpreted, I've very much had phone calls where it seems like a very heated conversation is going on between interpreter and client on the phone, and then the interpreter gives me a very short answer, and so I find myself having to flesh out, right? So it does speak to the efficiency and the accuracy of the interpreter, but I mean, yeah, there should be a much easier, and like, I've had clients who are deaf and hard of hearing, and so trying to get legal aid to approve a sign language interpreter on a repeat basis, just the amount of administrative time it takes out of the legal aid contract is it's absurd.
Yeah, that cultural piece is really important. I remember having a client where the concept of foster homes just did not exist where she came from. And so she didn't understand when her child was essentially placed with strangers. And she came to me and was like, why, what's happening? What's going on? Why is this? And like, and so like breaking down those pieces and explaining also eats into your legal aid hours, right?
And the idea that generally, unless it's a very special relationship or situation, parent will never meet the foster parent, will never meet the stranger caregiver. And that piece, the anxiety that creates in parents when they don't know, they don't know, and they don't know exactly where their child is. They know they're in a certain area. And certainly I've had situations with children placed on like the smaller islands off of Vancouver Island, where that's where the foster parent, the caregiver is, because in addition to the shortage of everything else, of course, there's a shortage of decent caregivers, foster parents, right? And the director wants to keep their foster parents. So they're willing essentially to bend over backwards to go, oh, it's fine that you live on whatever little island. Oh, it's fine that your schedule with your own children is such that you can only get a child to a visit with their parents once a week. And it's a very small child. My client's going, I need to see my kid more than once a week. And I'm going, I agree. So do we suck up our time with an access application, which is separate to the removal process, right? Or do we hope that we can work collaboratively with the director, with the ministry, the social worker? And that's very much a case-by-case basis. It really depends on the individual specific, not just the office, but the specific social worker that's assigned to be a child protection social worker for that family. And it's hit or miss. It's hit or miss. There are lots that are very easy to work with and easy to find. There are lots that has not been my experience.
So we ended there acknowledging some of the foundational pieces like housing that are needed before people have the energy and the bandwidth to participate in our legal system. Thank you so much for listening today. We'll be back again in 2 weeks to continue the conversation. Talk soon. Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer. We want to acknowledge that this podcast would not be possible without the generous contribution by Women and Gender Equality Canada, Femmes et Égalité des Genres Canada.